Good afternoon, everyone. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. Good afternoon, guys. Today, I decided to have this live presentation regarding some proposed rules, regulations about asylum law in the United States, asylum procedure. So it's a very important topic here because some of my clients are seeking asylum in the United States. I receive a lot of inquiries. Hi Zaid, how are you? Thank you guys for joining. So I decided to have this presentation to update you guys. Hi, good afternoon, Karin, about what's going on. Basically, what's happening is that we received a notice, Immigration Lawyers Public, about the proposed rules that the government is trying to implement, sufficiently eliminating an opportunity of somebody to successfully seek asylum in the United States. All right, so these rules, the proposed rules were published, I believe, yesterday. It was the day before, and they're going to be, it was an advance notice. They're going to be published on June 15th in a couple of days for comments. So the important part here is that this is not the final rule right now about asylum. Right now, the situation with asylum has not changed. But from the proposed rules and intentions, we can see that if those rules will go into effect, in my opinion, almost nobody will qualify for asylum in the United States. And I will explain to you why. The main problem, what we have in the United States is that in the United States immigration system is very complex in terms of laws and which regulations are going to be applying. We have administrative regulations, we have Board of Immigration Appeals, we have opinions of Attorney General, we have decisions by Attorney General, we have federal court opinions, individual judges' rules, okay? So what's happening right now is that government is trying to change the rules that are in place right now. And basically, if they do it, the asylum officers are going to have to follow these new changes. They will be bound by these rules, and it's not looking pretty. So let's start basically what's going on with what is being proposed. So the first thing that's being proposed is to basically will affect those who are seeking asylum at the border. People who are arriving aliens or labeled as arriving aliens, those who are going to be placed in expedited removal proceedings. And here is the situation. Even though the topic is vast, it's very hard to cover all aspects of it. But right now, let's say the person is at the border and is placed in administrative expedited removal proceedings. The person has a right for a credible fear interview, right? So when they pass that credible fear interview, Department of Homeland Security usually cancels that expedited order of removal that was issued against the person momentarily after the person was apprehended, and the person is placed into regular removal proceedings, so-called 240 proceedings. In those 240 proceedings, the person may file as a defense from removal, not only for asylum, but also, let's say the person gets married to somebody, perhaps with somehow they qualify for adjustment of status, even though if you cross the border, you're going to have an issue of unlawful entry, but assuming something like this, maybe VAWA relief. For VAWA, we don't have to have a legal entry, special immigrant juvenile status, and so on. So the basically 240 proceedings allow you, first of all, get out of jail because now you're eligible for bond, and second, allow you to have more protections, more thorough review of your claims. So the government wants to close that. They're saying that basically they will not be placing people now in 240 proceedings. That's their proposal. They say that if you are somebody who is in expedited removal proceedings. They're going to place you, they're going to give you a credible fear interview, but then if you pass it, you're going to go through what's called streamlined proceedings before the judge. Nobody knows what this is, okay? But basically, also, from what I understand, they're going to eliminate an opportunity of a bond during this time. So the person is going to be detained during this time. And that's going to serve as a deterrent. Basically, somebody who will be, or who would think about filing for asylum now will think, oh, I can stuck in detention for a long time, and that's the factor that they're trying to basically put in people's heads. Don't come because you're going to be detained, and it's not going to be what you think it's going to be. I guess that's the logic behind it. So that's one big change. But there is another situation here. You may remember that the government is trying to expand those who are going to be subject to expedited removal proceedings, including people who are already in the United States and didn't accumulate like 2 years of being in the United States. So potentially this situation may be applied, from what I understand, not only to people at the border, but people who are going to be here, all right? That's number one. If you read this particular part of the regulations with other parts I'm going to talk to you about, you will see that basically people who were here for a long time, or maybe for people who were here for a long time and trying to file for asylum, and people who were here for not enough time, will not be able to do it successfully either way. All right, very confusing, but I will explain what's going on. So number one, expedited removal and streamlined proceedings, okay? No more 240A. It's very, very important. And this is not for nothing that this point is mentioned the first in those proposed regulations. So then they're proposing to redefine what is frivolous asylum claim. And I have to say, I've been talking to my clients and people who I'm consulting with, I'm consulting for years about this. Be very careful with this situation, because basically what they're saying now is this. Currently, legally, you can be found to have filed frivolous asylum application only by the judge or by Border Immigration Appeals. But now they're trying to expand that authority to individual asylum officers. You would think that it would make sense to some extent, apart from the fact that it really doesn't, unfortunately. Because if in court, a person can explain himself or herself, right? And currently they have this opportunity, somebody say, well, you have a fabricated evidence. A person can say, well, wait a second, I don't agree with this allegation, give me more time and I will produce information that my evidence is not fabricated, right? There is no such an opportunity in affirmative asylum application, okay? You cannot really have this due process rights to explain yourself. And that's basically what they're saying. They're saying that once an officer determines that you have a frivolous asylum claim, you're going to be labeled as such, and you will have an opportunity to explain yourself, but it's going to be in court, okay? But then they go further. They say that the judge, if the judge will decide that you didn't meet basic criteria for asylum, the judge does not have to give you an opportunity to explain yourself, okay? So this is the essence of this proposal. Basically, asylum officer says, I think you have a frivolous asylum application, go to the judge. The judge looks at it and says, I don't think you were able to establish that you belong to a particular social group, and this is your case. You don't have an opportunity to explain yourself, because they say that the judge is going to have this broad authority not to listen to you. Because currently, the judge cannot do that really. The judge, unless the claim totally does not have any water to it, the judge will have to give you an opportunity to testify and present evidence. So this is a difference. And it's a very important difference. It's huge. So they're saying basically for you to be found to have filed frivolous asylum claim, your knowledge has to be actual knowledge or willful blindness. That's the standard, and they're trying to change it a bit. And now, another important thing, they want to add that if you filed it for improper reason, you filed for asylum for improper reason, then it's going to be considered frivolous. What do you think they're talking about, right? Improper reason that you don't qualify for asylum, but you just want a work permit in the meantime. Or perhaps they're talking about also all those filings that were done by people who accumulated 10 years of continuous residence in the United States and now filed for asylum, so that they will be referred to court where they will be able to apply for cancellation of removal. I think this is exactly who they're targeting here. And it's interesting because some years ago, actually USCIS suggested that that's how exactly people will be referred to court. They said, well, yes, there is an opportunity to file for a green card through the judge through a process called cancellation of removal. But for that, you have to be in immigration court. You cannot file for it by sending forms to USCIS. So how do you actually get to immigration court? Well, the government has to issue notice to appear against you and force you to go to immigration court. And how do you do that? Well, they said, why don't you submit asylum and we're going to refer you to immigration court. Why? It's because that's an established procedure in USCIS. If you file for asylum and you were found ineligible, you have a right to present your case in immigration court. So rather than saying that you can file your request to be placed in removal with USCIS or whoever designated official, they said file for asylum. That's what they said. And people did that. And then a lot of people did that. And now they're trying to combat that by imposing severe sanctions. Why the sanctions are severe? It's because if you're labeled as somebody who filed a frivolous asylum claim, you will never be able to get any benefits in the United States, immigration benefits, all right? So they're like pretty much death penalty in immigration. That's what it is. All right. Then the proposed regulation goes thoroughly through each qualification for asylum or each legal point that the person has to establish to win the asylum claim. They're trying to redefine particular membership in a particular social group, making it harder for people to qualify for this. They're saying, for example, that to qualify to be a member in a social group, a person has to establish that the group has members who share common unchangeable characteristics. The group is defined with particularity, and it's socially distinct in the society where the group exists. The group, then they go further, they say the group exists regardless of the alleged persecution. And cannot be defined by the alleged harm. What are they talking about here? They're talking about domestic violence. They're talking about gangs, when you are being persecuted by gangs. Because if you take away the element of alleged persecutory acts, you will not be able to define the group anymore. Okay, let's say now currently the groups may be defined as all Salvadorian women who are suffering, unable to leave the relationship, So, or let's say a family that is being targeted by gangs, a family also are big landowners. If you take away the element of harm to this group, it will probably not going to exist anymore, okay? Unless there is like a huge clan that's politically it's been developing in that country for years, and that's how they're socially distinct. That's one thing. Then they're going through political opinion. They're saying that political opinion no longer will include opinion or acts against the culturally norms, but only against the government, which very often are together, because if the government is supporting some cultural traditions that are wrong, okay, then it's your political opinion. Then they go in details about internal relocation issue, firm resettlement. That's a big thing in the proposed regulations. They're basically saying now that if you traveled through the territory of another country on your way to the United States, you will not qualify for asylum. Okay, and to my knowledge, almost nobody will, because unless you're coming from Canada or Mexico, maybe some other borders. I'm not sure who else is bordering with the United States. My geography is not so good, but basically, you got the point, right? So people will not qualify for asylum. They're saying that if you resided now, what's going on with firm resettlement? Now, basically, to lose your asylum claim because of the firm resettlement, you have to, if the government alleges that you can, that you resettle somewhere else, they have to show that you had a permanent residency there, an opportunity for citizenship, and you didn't exercise this opportunity. You didn't want to, for example. Now they're saying that immigrant or non-immigrant status, and you didn't have to apply for it. Basically, if the government is going to bring evidence that, let's say in Germany, where you had a change of planes, right, you may or could have applied for something, like any temporarily status that may last indefinitely, nevertheless, then you don't qualify for asylum in the United States. Very interesting, right? The rest of the proposal is as tough, but I'm going to focus on something that's going to be very relevant for most of the population here. Now, check this out. There is a thing in the United States law related to motions to reopen of one's removal order. They're saying that usually motions to reopen are limited in time and amount number, how many times you can file for motions to reopen. But there is no such a limitation on motions to reopen if you are trying to file for asylum based on changed country conditions, right? The idea is that if you can reside in the United States, even without status, for a long time, but your country conditions got so dangerous for you now that you cannot return, they give you an opportunity to file that motion as many times as you want, because the situation in your country can progress, right? So now they're saying that you're going to have 1 year to do that, okay? 1 year only, which, one year you may be able to file for it, but that's the first limitation. But you need to read the rules to understand all other things. Then they're saying that if you resided in the United States unlawfully without status for more than a year prior to filing your asylum claim, is going to be a significant negative factor in their determination. And if you put all this together, okay, it's basically means that those people who entered the United States and they resided in the United States, let's say for 5 years, now the situation changed. Let's say they don't have an order of deportation against them, but the situation changed. Regardless of their motives or anything else, just because they resided here for such a long time, it will be a significant negative factor in asylum case determination. Basically trying to deter people to stay unlawfully in the United States. Then they say that if you withdrew your asylum claim at any point, it may be held against you. Unlawful entry or attempt to unlawfully enter the United States is going to be a significant negative factor. There are some narrow exceptions. Let's say if you were a victim of human trafficking, okay? Fraudulent document, if you used a fraudulent document, which currently, believe it or not, is not a big issue, but they're saying that it will be a significant negative factor unless the person arrived from the countries sharing border with the United States. Canada, I guess if you're coming from Canada with a fraudulent document, spent more than 14 days. If a person spent more than 14 days in a country on a way to the United States, it's going to be a significant negative factor. Now, check this out. If you fail to file taxes, if you have taxes due, if you had income that seems to have been taxable and you didn't file taxes. It's very interesting because basically in the United States, a person to file taxes usually has to have Social Security number, and it's impossible to receive it unless you have a work permit, okay? So in current affirmative asylum situation where the interview is being scheduled within 60 days of filing and you don't qualify for the permit, it's basically impossible for you to file taxes ahead of time, okay, before you get your permit, unless of course you file and you get tax identification number. But from my understanding, I'm not a tax professional. It's very hard to receive that as well. All right, so taxes, and if you fail to come for the interview previously, so those are the main proposals, main changes. What we are seeing here is, as I said, in my opinion, basically almost nobody will qualify for asylum. Now, what I want you to take from this is this. Usually the way the regulations work like that, let's say these regulations in this form or perhaps in a little different form will be adopted. What happens is that as a rule, your claim will be subject to these new regulations if you file for it after the regulations are adopted. But again, it may be different because as we see, those people who filed for asylum and their claims contained were based on membership in a particular social group, and in the meantime, Attorney General changed the law, right? The way we looked at the law, people with pending claims were affected by the change that didn't exist at the time when they filed the cases. So, number one, you have to know about, if you have a pending asylum claim, you need to know about these possible challenges, if they will be affecting your claim, because right now I do not know if they will be, right? It seems that they shouldn't, but they may. Second, if you are planning on filing claim, and I would suggest that you do it now, before these new regulations come into effect, okay? And I will update you with more information. Again, these proposals are not the law yet, okay? This tax requirement filing, restriction on qualifying because you spent more than 1 year in the United States in unlawful status prior to filing. Let's say your visa expired and you stayed here and then you filed for more than 1 year. So these are not, this whole thing is not the law yet, but that's what they're planning. So you need to be aware of that, okay, and be prepared. Now, if you have some questions, I will gladly respond to them. Hi, Rizar. Hi, Ali. Hi, Mintra. Hi, Lena. Hi, Shafiq. Thank you. Hi, Ali. I got a problem. I applied for extension, but they still didn't reply to me. You probably filed for your work permit extension. You should have received the receipt. I have to say that during the COVID situation, it was we experienced huge delays in receiving receipts. Okay, sometimes even by month, especially for applications that were filed with Vermont Service Center. So I will not be surprised. As long as you have a tracking number that your package was delivered, you should be okay. Sooner or later, they're going to reply. Of course, you may be worried because you need that notice showing that your EID was extended automatically. But unfortunately, there is not much you can do. You may call customer service, but I find it useless, to be honest. Can you say something about permission re-enter? I'm overseas. Permission to re-enter, well, it's I-212 form. I believe I made a blog about this recently. So you can check my website, www.shautsova.com, when people file for it and how to qualify for it. But basically, the rule of thumb is that you need to be filing for a visa, okay? For an immigrant visa to be able to file that I-212 waiver. I think that's your question. And usually you file for it if you're overseas. You go for your interview, you get the denial, and then you submit your waiver. And depending on if there are other things in your case, let's say you also need to submit a waiver for something else, other grounds of inadmissibility, you may have to file 2 waivers at the same time. But I think I have a blog, and I'm going to, if I find the link, I'm going to post a reply to your question with that link, so it will be easier for you to find that information. I finished 10 years deportation in my country. My wife, oh, listen, if you served your 10 years, you don't need that permission anymore, okay? As long as other grounds of inadmissibility do not apply to you, all right? So if the only problem was in your case that they deported you with the word deportation because you stayed here unlawfully and you served your 10 years, you don't need any waivers, all right? If there was something else, then you may need. Can you please tell me Bangladesh people can apply for DV Lottery 2021? Really do not know, guys. For that, you need to check instructions to the DV Lottery, all right? I don't keep that information handy, I'm sorry. Can you please tell me Indian people can apply for DV Lottery in age 16? If you read official instructions to the DV Lottery, you will see the age restrictions, the qualifications. I don't believe a 16-year-old is going to qualify because one of the instructions of the points that you have to have a high school diploma or 2 years work experience. But instructions is the best thing. And by the way, the application period for DV Lottery is not active. The new DV Lottery entries are going to start only in fall. Okay, right now people only receive the results of what they were filing for last year. I need to do fingerprints. When they're going to reopen in New York. They publish this information on the website. I think that New York was set to reopen after this week, if I'm not mistaken. But to do the fingerprints, you need to receive a notice. Okay, you need to have an updated notice. They stated they're going to, USCIS stated they're going to email you the new appointments automatically for the fingerprints. All right. Hello, Anderson. Anya, hello, Miriam. I'm a US citizen. What am I supposed to do if my son is born outside of the United States? You should contact the embassy, and they will direct you. You should contact the consulate of the country where your son was born. Congratulations, by the way. And they will assist you with obtaining documents showing that your son is a US citizen, depending on the situation, but I'm pretty sure he will qualify for automatic citizenship. Hi, Walid. I need to do fingerprints. All right, I believe I answered that. I still don't hear from USS from February. They asked for stuff together, but they sent my daughter 10 years. Is it a problem? Okay, so I think your question is that your daughter received the green card and you didn't. If they asked for a fee, if you replied to it, I would think that it's just some technical issue. If your daughter, who's your dependent, received it, I'm not sure, do not know all the facts of the case, but it seems that, usually a child would qualify for a benefit only if a parent qualifies. So if your daughter qualifies and she did not have an independent relationship with a petitioner, then follow up with them. Okay, ask your lawyer to follow up with them and see what's going on. I have an asylum pending claim, high karma, but my spouse was selected for DV 2021. If I go back to my country and file a dependent visa, what are my chances? I actually have a video about this, guys. It's a tough topic, because basically, if you leave the United States, you're going to abandon your asylum claim. Plus, with all that's going on, they also can accuse you of fraudulent asylum claim. All right, this proposed regulation is just another proof to it, because they may say, listen, you filed for asylum claim, or your husband filed, but now you're going back, and without your husband receiving an immigrant visa based on DV lottery, you cannot receive one either. And if you guys are going to go back together, they're going to say, wait a second, we thought it was dangerous for you to go back, but apparently it's not a big issue for you, right? So what I recommend people in this situation is that you may try, but ask for a different consulate. I'm not sure if it's going to work with the DV lottery, I have to say. But let's say for employment cases, and I don't even know if it's going to work anymore. For employment cases, I recommend that people request to change the consulate where they're going to go to collect that visa, okay? Instead of going to your home country, because that may have a very strong effect. I applied for asylum in March. I received a letter of receiving the application, but I did not receive fingerprint notice till now. That's normal. Nobody has. Why? Because they can't fingerprint you. So as long as you have your receipt, you're okay. When the time comes, they're going to issue that notice for the fingerprints when they're going to be reopened again. I missed a little bit at the beginning. If you were saying about the border, US Canada, can you please repeat? Oh, yes, there was the issues were that, let me see my notes. They were talking about that if you traveled through some other country on the way to the United States, you will not qualify for asylum, okay? But basically anybody who's not from Canada or Mexico, countries that have border with the United States, will be traveling through some other countries, right? Otherwise, it's pretty much impossible for you to come in unless you can swim through the ocean, So the other part of it was about fraudulent documents. They were saying that if you used fraudulent documents to come to the United States, unless you're coming from the border countries, Mexico and Canada, they're going to hold it against you, against your asylum claim. But again, this is just a proposal. I do not want you to be afraid ahead of time. I just want you to be prepared, okay? Because that's very important. We're not here to make you scared. I'm here to make you aware, all right? So before you're going to make any decisions as to what to do next, do your research, consult with your attorney, okay? When people with immigrant will be able to fly, my mother, I know. This is a tough part. You mean the people with immigrant visas who got stuck overseas? Now, if she still has a valid visa, she should not have any issues. Well, right after the countries and borders will fully reopen. There are some limited flights already, but I do not have this information about every country. But if her visa will expire, she will have to contact the consulate, and they will ask her to present updated documents. That's very important, because there is a provision in the regulations governing the visas. Basically, the provision states that such a reissuance of a visa can be done for only good purpose. But of course, those regulations were drafted for normal times, not the pandemic times. So the consulate and the United States government confirmed that this will be the appropriate procedure. The person will have to contact the consulate, and the consulate is going to give them instructions as to how to present new updated documents like a medical exam, police clearances, so they will be able to reissue that visa. All right. Hi, Mr. Singh. My wife is a nurse, registered nurse. She didn't enter USA illegally crossing through Mexico. Can she be eligible for green card under healthcare worker? She still have pending asylum. Usually, for somebody to qualify for change of status, the person has to be in lawful non-immigrant status in the United States. So currently, if somebody has a pending asylum claim, it's not possible, because pending asylum claim is not a lawful non-immigrant status. If they make some changes to law, maybe, but from my knowledge right now, the person cannot adjust status while they have pending asylum claim, because now they have this huge more than 6 months gap in their status, usually they will have, and it will disqualify them from getting a green card in the United States. All right. Hello, Suren. What will be the possible criteria to be a sponsor for DV winner this year? Look at the regulations. But this year, of course, as you may be aware, DV lottery people are subject to public charge rules. So when we talk about the financial sponsors, in the past, DV lottery sponsors didn't have to file Form I-864, right? They didn't have to file under the regulations, even though in some cases they would be asked to submit an affidavit of support, a different form, I-134. So if I had to guess it, because of course I'm guessing here, I would say that the government is going to look at the income, all right? How much person is going to, how much money the person is going to have, the income compared to the person's liabilities and family size. And, you know, you can look at the regulations as to how much income they're going to be looking for. And the public charge regulations, they're really looking at 250% of the poverty guidelines level for the family size to find that the person's income is going to be actually a heavily positive factor for someone to be sponsored in the United States. So let's say money, that's what they're looking at, money, how much money the person is going to have and how much, what liabilities the person is going to have. All right. I do not have family members, but I would like to receive papers here. Hi, Mr. Diaz. Well, sure. Sometimes a person can get that, okay? But usually only if they qualify for very narrow relief, something like a U visa. U visa is a visa for victims of criminal activity, okay? If you've suffered some harm from criminal activity and you were cooperating with the police or prosecutor, whoever was investigating that, prosecuting that, then you may be entitled to status in the United States. Then there is something called T visa, visa for victims of human trafficking. I have a blog on that in the video. It's much more than just human trafficking of ladies, for example, through the border. It's also not just trafficking of people through the border. When we speak about human trafficking, a person may think, oh, somebody had to forcefully move me through the United States border. It's not the case. The definition is much broader than that, all right? It basically includes forceful labor, right? When you're forced to work for someone under the threat of immigration retaliation, and you know, you don't get sufficient pay for it, or basically working for free, it can include that too. So if you have something that may qualify you for those reliefs, you may want to speak to an attorney about that. Hey, dear Alena, is it possible to apply from China? What are you trying to apply for? It depends. I mean, it's some applications, of course, can be filed from overseas. Let's say application for VAWA, you know, application for U visa. Sometimes you can submit it if you're not in the United States, I believe. But asylum, you cannot. To file for asylum in the United States, a person has to be in the United States. All right. If the person is overseas, there is a special way for them to request a protection, but it's not going to be, it's a refugee status, but it's not asylum. All right, that's a little different than what we're here talking about today. All right, so guys, thank you very much for joining. I was very happy to see all of you and your comments. Please comment, share, like, and visit our website for more information. And I hope I will see you soon.